Welcome to our office hours. We have a guest speaker today who we are very excited about. So, Lee Lardieri is our coordinator of the dispute resolution team here at the Office of Special Services and Inclusive Education. So, over to you, Lee.
Thank you, Jennifer. Good afternoon, everybody. As Jennifer said, I'm Lee Lardieri, and I am the coordinator of the dispute resolution team on the Office of Special Services and Inclusive Education. And special education law has been a passion of mine for a long, long time. My background includes being a teacher, both general education and special education teacher, and also a special education administrator. And I have a PhD in special education. And so I'm very excited to talk to you today. And when I was putting together this presentation, I was saying to Jennifer and to Julie that there is so much that you can cover in special education law, that you can do it for 24 hours a day, 365 days a week. And so what I decided to do for this presentation today to hopefully make this hour useful and productive for all is to look at some of the common concerns related to MUSER and IDEA that we see coming through our office and through what we call the technical assistance that our team provides to the field. And so in putting this together, hopefully we'll get lots of questions and also lots of comments. If you wish to add anything to the chat, please do so. And in addition to that, at the end of the slides, you're going to see a QR code for you to just fill out a very brief evaluation form. Because one of the things I'll tell you right off the bat is that in my role at the department, I don't typically do presentations like this. So I'm not going to be as good as Jen or Carly or Ashley or Colette, but I'm going to do my best today. So I appreciate your patience. So the first thing I would like to ask you to do before I continue is if you could just put your role in the chat, teacher, administrator, special ed teacher, etc. That would be very helpful for me as I continue this conversation with you today. So can everybody hear me okay? I'm assuming that, oh, there we go. Yep. Somebody just put something in the chat. Thank you for that. So the slide you should be looking at right now is my team. And you may have even talked to David and or Alicia. David is our ed specialist consultant and Alicia, our legal secretary associate. And then I oversee the team, and I also I do complaint investigations for the department. That's part of my job. So Jennifer, next slide. So when we look at due process activities, and you hear the term due process throughout the work that you do. So as you know, parents and interested parties have a right to due process. The due process activities that we oversee on my team for the entire state, the ones required by IDEA, state complaint investigations, due process hearings, and mediation. The ones that are offered by Maine DOE and some, but not all states include standalone mediation and IEP meeting facilitators. So those last two, there are things that, especially the IEP meeting facilitators or facilitation of IEP meetings is probably the newest thing that we've added to our list of activities, and these facilitators that we have are trained in partial, and they will attend IEP meetings if you and the parents, let's say, agree to have a facilitator at an IEP meeting. And then all of these other activities I mentioned are also free of cost to parents and districts when districts have to participate in these activities. So we'll be talking about these things as I go through the slides a little bit more. And we'll be circling back to some of these things as we're discussing things. All right, Jen, next slide. So this slide, I apologize if it makes your head hurt a little bit, because when I was putting it together, I was getting a headache. But these are some of the most common issues from user and IDEA that are disputed or investigated in due process cases. And right at the top of the list, of course, is procedural safeguards, which are the parental rights, and FAPE, free and appropriate public education. And then the rest of these, child find, evaluations, eligibility, IEPs, and the different components of the IEP, placement and least restrictive environment. And then last but not least, of course, the behavioral and discipline issues, abbreviated days, and something that has been, I think, those of us who have been in the education field for a long time have always had staffing issues. There have always been teacher shortages. There have always been shortages of ed techs and whatnot. But I think, of course, through COVID, in the onset of COVID and in the aftermath, that has really accelerated or has really exponentially become a problem for many districts. And of course, as you all know, because you're out there in the field every day, when you have staffing issues and staffing shortages, you're going to have impacts on whether or not services can be delivered to students with IEPs. So we're going to be talking about each of these things. And thank you, Jen, for switching to the next slide. I want to talk for a minute. You're going to see the title, Procedural and Substantive Issues, on several of the slides as we're going forward. And when we're looking at procedural and substantive issues, some complaint investigations and some hearings involve one or the other or both. And sometimes they are intertwined with each other as allegations of violations of FAPE. So, for example, when we have parents calling us with concerns, and that would be the technical assistance part of what the OSSI team does. So we have folks that are on phone duty every day, and they're taking calls from constituents, mostly parents. And what these folks are talking to us about are concerns they have about their child's education, or disagreements or disputes they're having with the school over whether or not the evaluations that were completed for the child were appropriate and whatnot. And so these folks are giving us information about what they perceive to be violations. But in our world, we talk about them in terms of allegations, right? Because no violation or no allegation in an investigation or in a hearing, none of that is confirmed until those due process activities are completed. And so sometimes some of those complaints they have are procedural. Things like, I didn't get my child's IEP on time within the 2021 school days, or I didn't get the written notice. They talk about issues maybe with the written notice. And then some of the issues that folks allege are happening in their schools and concerns they have could be much more substantive than that. So, the golden rule, I guess, if you might notice on the slides, if you look in the bottom right-hand corner, that's just a little reminder for you is, the rule of thumb is to make sure that you stay on top of those procedural and substantive issues when you are conducting your business as special educators, whether it's getting the paperwork done on time, whether it's getting the evaluations done on time, whatever it might be. And that if you keep that steady workload up, and I know it's challenging to do that, but that is how you can show documentation that you are in line with what is expected from IDEA and MUSER in terms of procedural and substantive issues. So on this particular slide, we'll stay here for a second, Jen. We're talking about child find and initial referrals right now. And so you can see the bulleted items there, the timeliness of the response, convening the initial referral IEP meeting, notice of procedural safeguards to the parent. And then next slide, please, Jen. And then if you look at the things to remember and you look at these citations in MUSER to help you, go to MUSER, go to those pages, you should know and understand that parents can request a referral or evaluations at any time. Outside providers can make referrals. So if, for example, a medical doctor writes a letter to the school and the letter says that the child has been diagnosed with attention deficit disorder, and the medical doctor might make a reference in there or a suggestion that maybe the IEP team needs to take a look or meet with the parents to talk about the issues the child is having in school, that is considered to be a form of a referral. So you have to follow up on that. Children experiencing chronic absenteeism or housing instability, they are entitled to child find, as are children receiving home instruction or in parentally placed private schools. They're also entitled to child find. So when I used to attend webinars like this or professional development, part of it is in your head, you're kind of doing a mental checklist to say, yep, we're already doing those things. And you're kind of giving yourself some affirmation, and you should give yourself some affirmation and a pat on the back if you're doing those things, because those are the things that are going to keep you in procedural and substantive compliance. So in terms of evaluations, the important things to remember: consideration of all suspected areas of disability and referral questions. Remembering those are IEP team decisions. Obtaining signed parental consent to conduct those evaluations. Consideration of parent-initiated evaluations. And I point this one out because in some of the phone calls that we do get, and in some of the requests for complaint investigations, some of the allegations from parents, and again, they're allegations, they're not violations unless they're investigated and they're found to be. Consideration of parent-initiated evaluations. The perception of some parents is that if they have a parent-initiated evaluation, we call them outside evaluations, and they bring it to the IEP team, that it is incumbent upon the IEP team to follow the recommendations and the diagnoses in that evaluation to the letter, because it came from a neuropsychologist, or it came from a pediatrician's office, or some other outside psychological service provider. But the answer to that is no. So you know that as an IEP team, you have to consider those evaluations, but it doesn't mean you have to follow them to the letter. And that can be confusing for families sometimes because, as you know, many families go out and they pay hundreds of dollars, sometimes thousands of dollars, to get very sophisticated neuropsychological evaluations completed, and then they're disappointed or they have concerns when the school won't follow those diagnoses to the letter or act upon every single aspect or every single facet of those evaluations, including the recommendations. So the other common things that you know about are evaluation reports are due to parents within 3 days of an IEP meeting when those evaluations are going to be reviewed. And then this last point here, having trained qualified evaluators is something that is important to not only complete those evaluations, but this second part is important, to interpret the results for the IEP team. And one thing I think that folks can get hung up on is be mindful of the qualifications necessary to be able to conduct those evaluations and interpret the results at an IEP meeting. And you all know that that information can be found on the websites of the publishers of those tests. So Pearson is probably one of the biggest publishers nationally of those tests that psychologists use, special ed teachers, speech and language pathologists. And so if the IEP team is going to review the results, let's say, of an outside evaluation, you have to ask yourself, is the person who is going to review and interpret the results of, let's say, a psychological evaluation, is that person qualified to do so? And I know in these times of staffing shortages, sometimes it's difficult to get all of the people at the table that need to be there for the interpretation of those evaluation results. But I would just caution you to make sure that you have the right people around the table. So can I get, thank you, Jen, before we move on, can I just get a sense of, I know there's 3 of you there in the chat. I just maybe could get a thumbs up or an okay or something that the pacing is okay and that what I'm talking about is making sense. So Diane, Michelle, and Katie, if you wouldn't mind, just give me a thumbs up or something. Okay, thank you. All right.
Lee, we've had more people come in and I've seen some thumbs up on the screen too.
Okay, all right. Thank you. So here's 2 things to remember. And this is, again, taking a look at what are the things that people are calling us about? What are the things that people are concerned about? Certainly, it's not a comprehensive look of everything. If you turned over every rock in Muser about evaluations, you'd know it would be pages and pages of things. But in the time that we have, 2 things to remember. In conducting the evaluation, the SAU shall not use any single measure or assessment as the sole criterion for determining whether a child is a child with a disability or determining an appropriate educational program for the child. And the second one being, evaluation reports shall not make either eligibility or placement determination. These determinations are the responsibility of the IEP team. And I say those things because I have either been a special ed teacher as a participant or a IEP coordinator or supervisor where I was chairing IEP meetings in a school district. I did that for 19 years. So, to sum things up, I probably attended hundreds of IEP meetings. And so over those years, sometimes, not always, but you tend to see teams, IEP teams, relying heavily or more heavily than not on the results of a psychological evaluation. Or you might see where an evaluation report, at the end of the report, maybe one of the recommendations made by the person who wrote that report, whether it be an occupational therapist or a psychologist, or I'm not trying to target anybody, but it could be that in their results, they make a recommendation that says that they think a child should have X number of hours of services of OT, let's say. And so that evaluation report should not be making that eligibility or placement decision. What that evaluation report should be saying is that it's up to the IEP team to consider the results of this evaluation with the others. And then the team makes those decisions. Okay, next slide, please. So the next 3 slides about evaluations, I took right out of Muser because I thought this is an important point to remember about evaluations. As you know, sometimes parents will ask for or request independent educational evaluations. And I'm not going to ask anybody to do a thumbs up on this or not, but just, sort of self-reflect if that's happened in your district. Maybe it's never happened to anybody that's in this webinar today. Maybe it has happened. But what you really need to remember about this is that there are 2 things that a district must do to respond to those requests. One of those is that the district, and you can advance to the next slide. One of those is that the district could go ahead and honor the parent's request and at no cost to the parent pay for that independent evaluation at public expense. The second thing that a district must do is, if they're not going to pay for that evaluation at public expense, then they must file for a due process hearing to basically show that the district's evaluations are appropriate. And then a due process hearing officer, an independent due process hearing officer, would rule upon whether or not the district's evaluations are appropriate. And so if the public agency files a due process complaint to request a hearing and the final decision is that the agency's evaluation is appropriate, the parent still has a right to an independent educational evaluation, but not at public expense. So in other words, they can go out and pay for their own evaluation, and they can come back with those results and present them to the IEP team for consideration. But if a hearing officer rules that the public agency's evaluation is appropriate, then the district does not have to pay for that. So just looking at the last 2, number 4 and 5 under B, parent right to an evaluation at public expense. These are just directly out of Muser and out of IDEA. The reference at the top there is to IDEA. But if the parent makes such a request, the public agency may ask for the parent's reason why he or she objects to the public evaluation. But the public agency may not require the parent to provide an explanation, and it may not unreasonably delay either the provision of that independent the IEE, Independent Educational Evaluation, or filing for the due process complaint. Okay, Jen, you can switch to the next one. So the eligibility determinations, and again, thinking about the theme of this presentation is what are the main concerns or some of the main concerns that we see coming through either our technical assistance call center or through our Office of Dispute Resolution. So this is a very common one where this literally happens. This is the way it happens. So we may get a phone call from a parent who's out of breath because they just left an IEP meeting and it was an eligibility meeting and their child was not found eligible for special education. And so they decide to call the state to get some clarification on that. And then once we sort of gauge what the concern is, then we can talk to them about the three-prong eligibility standard under IDEA. Because there is a common misconception among some school staff and parents that to be considered eligible for special education, the IEP team only needs to consider prong 1 or prongs 1 and 2. So these out of breath folks, and of course, you know, these are parents who care very much about their children and they're very strong advocates for their children's education. They're upset because they say my child has a disability and there's an adverse effect, and yet the school is saying that they don't qualify for special education services or an IEP. Or the other folks might say that my child has a diagnosis from a doctor of autism, but the school is saying they're not eligible for special education. So it's talking folks through this process. And a good idea would be, as special educators, to talk to your staff and talk to them about what does the three-prong eligibility standard mean, and that there are 3 things that need to be considered. Is there a disability? Is there an adverse effect? And does the child need specially designed instruction? And that third one, especially under that educational need, as IEP teams convene, they can consider the first 2 prongs and answer yes to those. And the third prong could be that this child's educational need can be met in the general education setting. And as you know, as practitioners, sometimes that's very surprising to the staff that you work with that may be general education staff, because they're just not aware of what the 3 prongs really have to say. So I think this is just an important point about eligibility determinations, which cannot be emphasized enough. And while the IEP team is convened, while you're sitting around the table, this is where you might want to say we have to look at the 3 prongs of eligibility so everybody around the table understands what those are. And next slide, Jen. As you know, if you look at the forms that are also utilized during eligibility determinations, these forms talk about those 3 prongs of eligibility. If you know very well the adverse effect form, for example, at the bottom of the last page, it talks about whether or not a child has a disability, is there adverse effect, and whether or not the adverse effect can be addressed in the general education curriculum, or does the child need special education? And same thing with the other 2, specific learning disability. You may have, and you can answer this by, you know, giving me a thumbs up or not. How many of you have had parents come to a meeting, let's say, and they say that my child has dyslexia? And when you go through the specific learning disability for evaluation or the eligibility form, sometimes that child may or may not qualify because they get through the first two prongs, but they do not need special education services in order to be able to successfully access the curriculum. So you've got this parent saying, my child has dyslexia. You've got this child who is in maybe some sort of reading intervention, and yet the parent is going to dispute with you whether or not the child has a disability. And so a couple of things there. One, you can talk about, again, the three prongs of disability. The other, and I'm sure some of you have had this conversation with parents, where the word dyslexia is actually embedded in the definition of a specific learning disability, and that's right out of Muser and IDEA. So you can respond to parents who talk to you about dyslexia by saying, when it comes to Muser and IDEA, that dyslexia is under that category of disability that we call specific learning disability. Is everybody familiar with what I'm talking about when I say there's more and more folks that are coming to your schools saying that my child has dyslexia? Does that sound familiar? You can just give me an all good or a thumbs up or yes or something. Nobody. Oh, here we go. Okay, there we go. Yeah, and again, it's not with every single case that we get, but we've I would say in the last couple of months or so, we have had some cases where we dealt with that allegation from a parent that the school is not addressing my child's dyslexia diagnosis, when in fact, the child or the school may be addressing it because they're calling it specific learning disability, and this is what this is what the school is doing to address that. So it's helpful. I think it's helpful to parents and even your staff, your school staff, to make those distinctions and clarify for people what dyslexia looks like in the world of Muser and IDEA. All right, I think we can move on now, Jen. So things to remember: IET, the decision-making process and parent input. And I'm going to talk about that a little in a little more detail here in a minute. Ensure that the parents receive a copy of the adverse effect form and the specific learning disability eligibility forms. And of course, notice of procedural safeguards when going through those eligibility determinations. Can you just step back for a second? Okay, thanks, Jen. So that first one, IEP decision-making process and parent input. Often when we get requests for investigations, we get allegations, and a common concern that we hear from parents. They don't feel heard at IEP meetings, or they feel they've been shut down at IEP meetings. So just be sure that parents have an opportunity to give their input during those IEP meetings, and then document that. And most of the time, you folks are you're already doing that. But just remember that that you're going to have folks that will call us and say that they don't feel heard, or they feel like they've been shut down at meetings. And those are the words, the word shut down in quotes, because that's what we hear from people. All right, now next slide, Jen. So before we talk about the development of the IEP, just kind of doing a check for understanding make sure everybody is still good on their water and snacks, if that's what you're consuming right now while you're listening to this presentation. Everybody doing okay? Any questions? Okay. Thank you. So development of the IEP includes special factors, the PLEPs and IEP goals. Now, I used to call them PLEPs, and I wonder if anybody from the federal monitoring team wants to shout out and say, no, they're not called PLEPs anymore. They're called something else. But the PLEPs would be the present levels of educational performance. Anybody from the federal monitoring team want to weigh in on that?
You can call it whatever you want, Lee.
Okay.
We're not picky.
Okay. Supplementary aid, services, modifications, and supports, services, and placement, and least restrictive environment. So looking at this slide, based upon the needs of the child, and make sure there are inclusive discussions. And what I mean by the inclusive discussions is it kind of connects back to what I just said about parent input. And if you look at that reference in Muser about parent input, it talks about the IEP team process. The decision-making process is the vehicle for parent communication between the school and the parents. And so the inclusive discussion about those considerations, including the special factors, the PLEPs and the measurable goals and objectives, if applicable, the supplementary aid services, modifications, and supports that'll be in place, the services that will be in place, and the placement or the LRE where the services will be delivered. So if it's specially designed instruction, we know that that can be delivered in special education setting or the general education setting or the regular education setting, as your IEP probably says. And so it's having those open discussions and including everybody and giving everyone a chance to give their input. So if advocate of the parent, like a targeted case manager, attends the meeting, you want to make sure that you give that person an opportunity to give their input. And again, can't say enough about making sure that the parents have input, because as I was saying, sometimes we get calls from parents. We also get calls from targeted case managers that are calling on behalf of the parent, and they're saying things like, when we were trying to talk about our concerns on what we thought the child needed, we were shut down. And so again, we look at those issues, and sometimes that's true and sometimes that's not true. We look at them as an allegation. We don't automatically assume that a district is shutting down the parents and not giving them an opportunity to provide their input. But what I'm saying to you today is that these are sometimes some of the things that we're hearing from the field. And I'm sure that you've actually heard some of those things from parents in your districts as well. Whether it's true or not, they're going to tell you what they perceive to be happening, right? So when I bring up Andrew F. versus Douglas County Schools, is everybody familiar with that landmark Supreme Court decision?
I'm seeing some nodding heads, Lee.
Okay, good. I'm not sure why I can't see everybody, but that's okay. I don't need to see everyone. So as Andrew F. and versus Douglas County Schools, there's a lot to read. If you ever read the actual Supreme Court decision, there's a lot of things in there that the justices had to say about this issue. But the common sort of understanding is that IEPs should be ambitious and reasonably calculated to ensure that a student will receive more than just a de minimis educational benefit, to make progress in light of their circumstances. So what the justices were saying there is they're not saying that kids with IEPs should be making progress with their age appropriate peers or their grade level appropriate peers in terms of grade level expectations or grade level academic achievement. What they're saying is, in light of that child's circumstances, that they should be given an IEP that is reasonably calculated and ambitious. And so I think where districts can get hung up and unintentionally hung up is if you go to an IEP meeting, and I've heard this many times, again, like I was sharing earlier when I was in practice in the field, after attending hundreds of IEP meetings over the years, where one of the, particularly at an annual review, you might hear one of the service providers say, well, Johnny did not meet their goals, so we're going to keep the same goals. Well, that's kind of a slippery slope. So because I'm not an attorney and I'm not here to give you legal advice, but what I would say is to ask yourselves a question as an IEP team: is the IEP that we are proposing for this child today, is it ambitious? Is it reasonably calculated so that this child would receive more than a de minimis educational benefit? So you have to ask yourselves as an IEP team those questions. And that if a child is not making progress on goals or didn't meet all the goals, there should be an effort by the IEP team to still write new goals for that child's IEP. And so just to be mindful of that. And again, going back to why we're here today, we do get calls from people and we do get complaints that are filed with allegations that their child's IEP is not ambitious enough, and that the goals, and if the child's IEP has objectives, that the goals and objectives are not ambitious enough for the child to make progress in light of their circumstances. So I think that's just an important, if you're going to read any Supreme Court case, I think that's an important one to read. And I believe we have a link to that on our OSSI webpage. Is that right, Jen? Jen?
Yeah, sorry, I couldn't find my mute button.
Oh, okay.
Yes,
I believe, yeah, there's a link to that
on our website for that. And Lee, we're at 15 minutes to go.
Okay, thank you. I'm just looking to see where we are on what slide we're on here. Go ahead and go to the next slide, please. Okay, development of the IEP. Unilateral placement decision, be careful about making them, or be aware that parents may decide to parentally place a child and then request tuition reimbursement. Review and revision of the IEP. If a student is not making progress, a team should convene the IEP meeting and review and make revisions as needed. Even though Muser says you only have to meet once a year, at least once a year, right, for the annual review, you have to pay attention to the progress the child is making and convene a meeting for review and revision of that IEP if necessary. And there's the Andrew F. reference that pertains to that piece as well. Written notices. Make sure what's recorded in the written notice and what is written in the IEP are the same. And then the timelines that that folks are all aware of. Jen, next slide. Okay, so we're getting down to almost to the end of the presentation, I believe. So procedural and substantive issues when it comes to discipline of students, behavior discipline, and abbreviated days. So those suspensions and disciplinary removals, manifestation determination, FBAs, and service provision for students while they're in an interim alternative educational placement. So I'll say this about manifestation determination meetings. Make sure that you have administrators and teachers who can speak to the details about the behaviors or the incident that led to a student's suspension. Review all of the data and information before making the determination as to whether or not the behavior which led to that suspension was a manifestation of the disability or not. And don't forget about part 2. Make sure the question of whether or not the behavior which led to the suspension occurred due to a failure to implement the IEP. Make sure that's addressed as well. Next slide, Jen, please. So, under the discipline of students with disabilities and special circumstances, there are 3 special circumstances in which students, regardless of the decision of the IEP team as to whether or not the behavior was a manifestation of the disability or not, 3 circumstances. If a student brings weapons, drugs, or inflicts serious bodily injury on whoever they were targeting, then regardless of the decision of the IEP team, that student can be suspended for 45 days. And some of the misconceptions and or concerns that parents have, number one, there are some misconceptions by folks that students with disabilities cannot be suspended at all. And we know that that's not true. They can be suspended for up to 10 days, either consecutively or cumulatively in a school year. And under these special circumstances, they can be out for 45 days. Now, you know, in a manifestation determination, if a student is suspended and it's found that the behavior which led to their suspension was a manifestation of their disability, as long as there are no special circumstances, then that student needs to be returned to their placement. If the student's behavior which led to the suspensions are not manifestation of the disability, then you know that they can be disciplined like any other student. But either way, whether students with IEPs are out of school due to suspensions, whether they're manifestations or not, they need to continue to have services. So there needs to be some kind of educational service in place for those students. And then with abbreviated school days, there are 2 reasons in Muser, and I'm sorry I don't have the Muser reference. I should have put that on the slide, but I'm going to try and copy and paste it into the chat for you right now. Okay, there it is. So with abbreviated school days, there's educational or medical reasons. For educational reasons, students can only be out for 45 calendar days, and then the IEP team needs to meet within that 45 days, and then every 20 school days, the team needs to meet. And one of the biggest things that becomes an issue for districts is they do not have a reentry plan, or the reentry plan that has been written is not adequate in terms of returning the student to full days of school. And you'll see on the next slide what I'm talking about. But I just want to make a quick comment about abbreviated day schedules for medical reasons. So under the same user reference that I put in the chat, for medical reasons, students, IEP teams should meet no less frequently than every 90 calendar days. And you can look up the details in those user references. So for behavior, discipline, and abbreviated days, the things to remember: document, document, document. Use those positive interventions and supports. Conduct those functional behavioral assessments. Thank you, Jen. Behavior intervention plans. For discipline, suspensions in school counts as a disciplinary removal, so you've got to watch for that. Sending a child home or calling parents to pick up a child counts as a disciplinary removal. So if you're talking about counting your days, your 10 days, you have to factor in those instances. Manifestation determination. What I already said is that students must have educational programming, including access to the general ed curriculum. And abbreviated days. Adhere to timelines. Reentry plan, reentry plan, reentry plan. Okay, Jen, next slide. So this has to do with the staffing shortages. In Muser, as you know, there's a section called Implementation of the IEP Program in Effect. Teams must meet every 30 days to come up with alternative solutions if staffing shortages are the reason why students are not getting services. And that team should be looking at ways to reconfigure the staffing assignments to ensure that services and supports are in place. And this is where I'm talking now to IEP administrators, but you know, as a director or assistant director or coordinator, involve your district level administration to help you problem solve and support the recruitment of staff, substitute teachers, and ed techs to help you with the staffing shortages issue, because it's not just a special ed issue, right? And it shouldn't be all on your shoulders. You should be getting help from others in your district. Okay, next slide, Jen. Oh, good, we're coming down to the end. All right, so here's just some other thoughts I put together. Parent input and communication is key. Most of the time, you may have all your ducks in a row, but complainants may still file because they can. So I'll have conversations with directors and they'll say, I don't understand why that parent filed a complaint or called you, because we have all our ducks in a row. We're always doing everything correctly, procedurally, and substantively. We're bending over backwards for this family to try to support their child. And yet people are still going to complain because they can. They have a right to due process. Allegations may or may not result in violations. It depends on the totality of the facts in a case. And I think this, I'll leave you with this last thought, and I think we're down to 2 minutes. I'm looking at my clock and it says 3:58. If your district finds itself in a situation where violations are found in a complaint investigation or a hearing, we as the OSSI team members, we know these situations are stressful for you. We know they can be upsetting. We know they can be eroding the trust between parents and schools, and we know that you try very hard to build rapport and relationships with the families of the children that you work with. But if you can, and there is corrective action, if you can, try to take it as an opportunity for learning and technical assistance. All right, next slide. This is our contact information for the due process office, or the dispute resolution office, I should say. And then the last slide, we have 1 minute. So I would really appreciate your feedback. Please reach out to us, because as I said at the beginning, I'm not as good at doing this kind of presentation as the people in on the federal monitoring team. I look up to them as the gold standard, and I tried to do the best that I could today to meet their expectations and yours. And so I thank you for your attention today. And again, please give us feedback. Please reach out to us if you have any questions. And if there are any additional questions that come through on the, goes right to a like a Google form, but it's a Microsoft form. I can answer those questions for the group and put them in the feedback and contact our link that looks like that Carly, thank you, Carly, that Carly has posted in the chat.
So that's a separate link.
Okay.
Lee, it's not yours. Sorry.
Right,
That's
right.
to get your contact hour. And
Yep. Okay.
so there's two different things for you to do, guys. You have Lee's form, and then the one in the chat is to get your contact hour for being here with us today. And with that contact hour, you will get goodies like this this PowerPoint and IEP quick reference document, and I don't know, whatever else Carly throws in their goodie bag there. I don't remember. I don't know. It's late. I don't know what day it is.
Thank you very much, everybody. I appreciate your patience, and have a good rest of your day.
Thank you, Lee. That was awesome.